So, you finally saved up all this money, you're doing really well, and you're like, man, I wonder what happens to this money like when I'm gone. Well, after you're gone, several things can happen to your bank account. Right, depending on the type of account you have and how you have it set up, and whether you've set up a will or a trust. Let's talk about some of the common ways, the things that we need to do, right? And you should learn some of the common ways you can set up your account to make things as simple as possible after you're gone, and what's going to happen if you don't set up anything, right? So first things first, you need to name some beneficiaries. By far the easiest way to pass on the stuff in your bank account, is to your heirs is to just make sure you name payable on death, right? POD beneficiaries of your account. Now, payable on death beneficiaries differ from standard beneficiaries in a very distinct way. If you pass without a will in place, then the estate is declared in state and will go to probate instead of directly to your beneficiaries. If you want money to go to your survivors in the simplest, quickest, and least stressful way possible, then you want to avoid probate. I mean, you really do. Once you've named a payable on death beneficiary, they will not have direct access to your money until you're gone, and you still retain the ability to change the named person at any time. This option is frequently referred to as the poor man's trust, since it essentially acts as a trust that easily transfers money to the person you designate. And you can change it at any time, and you don't have to set up a costly trust through a lawyer or maybe pay some fees anytime you want to make changes. If you have listed someone as that beneficiary on your account, then after passing, all they will need to do to access the funds in the accounts is to show a valid government ID and a copy of your death certificate. Well, you should have a will, right? I mean, come on. If you have a will in place, your heirs still may not necessarily avoid probate, but at the very least, you'll have a guideline in place for who gets your assets. Now, the probate process can be very lengthy, and your heirs may be required to hire costly probate attorneys, depending on where they live. And, your will becomes public knowledge after your passing, and assets passed on through wills may still be subject to estate taxes. Another thing is to set up a trust. A well set up trust is going to avoid probate and can reduce tax liability for your heirs. Unfortunately, not all trusts are equal, and they're not always set up perfectly. Trust can be extremely expensive to set up and maintain and may not be worth the cost if you have a simple estate with few assets and few potential heirs. One of the other things that you could do is you can add account holders. And by adding account holders to your bank accounts, it can make things easier for your heirs after your passing, but it can have downsides while you're living. Most joint account holders are considered joint tenants with rights of survivorship, which means that the account just passes to the survivors when an account holder dies. You need to check with your bank if you're unsure about the status of your account. Having multiple account holders can be complicated while you're living. The other people named on your account may be subject to gift tax and have the ability to withdraw funds from the account whether you want them to or not. Additionally, the assets in the account are legally considered theirs for the purpose of qualifying for government programs or if they have a creditor with a judgment against them. Make sure that you trust the people you're naming on your account and think through the possible ramifications before you do so. Well, what if you don't have anything set up? Well, you're not going to do none of this. Well, if you don't set up anything before your passing, then your accounts are going to go to what's called probate, and they'll be distributed according to the state's laws. In most states, an executor will be appointed who will be responsible for paying off any creditors of the deceased. The remaining money will be distributed to the spouse and children of the deceased. If the deceased has no survivors, no will, or no trust, beneficiaries, or joint account holders, the estate's funds will go to the state in most cases. Like I said earlier, you really want to avoid probate. You know, if you have a simple estate with no assets other than a bank account, then adding a payable on death beneficiary to your accounts, it's going to be the easiest way to avoid probate. If you have a complex estate or multiple heirs, you want to leave things to a trust may be your best option to avoid probate. Now, when you do this, you might ask, well, do the people inheriting this money, do my heirs, or do they have to pay taxes on the money in my account? Well, that depends. Estate taxes have a really, really, really high threshold for the normal person. In 2022, this threshold is $12.6 million. Like, it's really high. Now, gift taxes in comparison come into play if you gift your heirs more than $16,000. So, a common strategy is to gift your heirs up to the annual gift exclusion yearly if your main goal is to avoid gift taxes and your estate is small enough that you could gift away most of it to people who would gift it back if you're in financial need before your passing. So there's a lot of lessons to learn here, but let's take some of these step by step and talk about them. The first one is adding payable on death, right? POD beneficiaries to your account. This is going to be your easiest way and your cheapest way to make sure your heirs have just easy access to your account after you're gone, right? Remember, so adding the payable on death beneficiaries, cheapest and easiest. Now, I would recommend, at least setting up a will. Setting up a will or trust can help your heirs access money after your passing, but may still go to probate. Now, remember, we want to set these up in a way where we don't have to worry about probate. We don't want to deal with probate. Third, adding joint account holders with rights of survivorship makes things simpler after you pass, but it can lead to complications while you're alive. It could be a pain, okay? And then doing nothing will make things extremely complicated, extremely stressful, right? All for your survivors after you're gone. So, for their sake, please make sure you have something in place: a will, a trust, payable on death beneficiaries, something, but just something. At bare minimum, I would say set up a will, right? Hopefully, you guys got some good information out of this, and you have a good direction to go with some more research if you're looking for something. If you've got any questions, you go ahead and ask them down below. If you like the video, hit that thumbs up button. Subscribe if you're not subscribed already. But until I see you guys in the next video, y'all be safe.